Let me bring in Martin Kpebu on this one. And I mean, look, it didn't go the way of the speaker, but at the very least, he went back to the same court that made the ruling and sought to correct it that way. Unlike others who called for, us to hit the streets and all of that, Dr. Toniedu, was quite adamant that he didn't think the solution to this problem could come from the Supreme Court. He expected an outcome like this. And like others, he is of the view that the Supreme Court is now predictable in the sense that their rulings tend to favor one side more than the other. Does yesterday's proceedings in any way suggest that, or do you see legal? Do you see that they followed legal tenets in giving yesterday's ruling?
Oh, Kojo, unequivocally, I'll go on the predictability. I'm sure you know me by now. I just have to say it the way it has to be, because otherwise I'll be letting down our democracy. Listen, Kojo. Yesterday, Lawyer Sorry was fantastic. Look, there were too many points to be brushed aside. There were just too many. At least one could have clinched the day. This thing about Ex-Parte, listen, Kojo, is doing violence to the very education that we had in the law school. This Ex-Parte thing, you see, yesterday, Lawyer Sorry quoted the Barclays Bank versus Kpebu. It's an anomaly. It's not usually done like that. That's how come it is restricted to 10 days. So somebody comes before you, Ex-Parte. You see that even Lawyer Kpebu, the Afenyo-Markin's lawyer, you read the proceedings of 18th October. He stated that he wants it for 10 days because that is the practice. And the practice, apart from, so even though it's in the Supreme Court, yes, that's why it's CI 47, and that's also the practice. So that order that the Speaker's decision is suspended till they finish hearing the case could not have been given on an Ex-Parte application. No, they should have given it for 10 days. So that one, 100 years, I will tell you unequivocally that was wrong. Listen, we have to disagree with the Supreme Court. If we don't do that, it won't change. Because it's the same law. Could you let's be very clear? It's the same training we are all giving. No, the same training. You don't write an exams to go to the Supreme Court. No. So I was called 17 years ago, right? That exam I took, I qualified to sit on the Supreme Court as soon as I got 15 years at the bar, provided, of course, no moral turpitude and those things, right? Yes. So that exam I took 17 years ago, that's it. You qualify to sit on the Supreme Court. So you see now why people will bring in politics, etc. Because it's the same text we are all qualified in reading. Of course, we have different pedigrees, depending on what you read, etc. Right? But you look at this thing, I don't see what is rocket science about it. It is a settled practice that when somebody comes Ex-Parte, you limit the order for 10 days. I don't know how anybody wants to defend what the Supreme Court has done. Yesterday, I saw the court making a last-minute effort to now defend it under Article 2. Look through the proceedings of 18th October. You don't see them bringing in Article 2. So yesterday, it was too little, too late. This decision, to be honest with you, it's just, as Kweku says, chipping away the trust that the court has and immediately bringing to the fore a new design when we go for constitutional review. When we're going to amend the constitution, we have to take away the power of the president to appoint Supreme Court judges because you don't get much independence. Because to be honest with you, and I'm telling you what, I can defend this anywhere, that the decision has already, I don't think, you see, so in law, yes, they can defend it that, they can do so. But that is not our practice. Ex-Parte order. Then you say, I'm giving the order till the end of the case. I've never heard of it.